It's Kristen Gruwell with Century 21 Goodyear Green, live from Edmond today. Drop a comment below and let us know where you are watching from. Today we're going to talk about probate trusts and how that all affects real estate here in Oklahoma with Aaron Budd of ABC Legacy Law. If you can't hang out and watch now, don't worry about it. You can always come back and watch the replay. Hey, Aaron, how are you?
I'm doing well. How are you doing? Thanks for having me here, Kristen.
Oh, no problem. I met Aaron just a short time ago. He came in and did a little bit of continuing ed over at our Edmond office, and it was a lot of useful information. And it's kind of something that I have a little bit of experience in on the real estate side because Aaron, you may not know this, years ago, I used to actually, in addition to real estate, facilitate estate sales. And so very often I was in a position where I was helping someone sell their house who had lost a family member, and they were faced with having to sell their house as well as all of the personal property. And, often they would come to me. Sometimes there was a trust, sometimes it had to go through probate, with all different kinds of situations. But almost every time the survivor was caught kind of unaware as far as what to do, which made me think, it would be helpful if you could talk to some of the folks out there and help them, learn what they can do to avoid being in that situation.
Yeah, so really it comes back to planning. And really when I'm talking with people, let them know what their options are. Of here's what happens if you have no plan. Here's what happens if you have a will-based plan, or here's what happens if you have a trust-based plan. And either way, it really comes down to what kind of planning, what kind of result do you want to have happen, and how do we get you there? And so, go ahead.
Oh, I was just going to ask, so what happens, when someone dies, they lose someone, and then can that house can it even be sold right away? Who gets to make those decisions, and how is that even determined?
Well, that's a good question, and it varies on a lot of different things. It depends on how title is held to the property. There's a husband and wife, and the husband's passed away. Then if they held the property as joint tenants with rights of survivorship, then the wife would be able to obtain full title to that house by operation of law by filing paperwork with the county clerk in which the property was located. And that would be an affidavit of surviving joint tenant with a copy of the death certificate, and then title would move from husband and wife as joint tenants with rights of survivorship to the wife individually. Now, with that, the wife would be able to sell once that paperwork was filed with the county. If title was not held in that way, say the husband owned the property in his own name, well, then we're going to have to go to probate, because the probate process is a legal process designed to do for you what you can no longer do for yourself. The husband has passed away. He can't buy, sell, refinance that property. And with real estate, the only way that you can transfer it to the wife would be through probate.
And so even if they are married and it is just in one individual's name, it's going to have to go to probate.
Yes, the ring does not protect against probate, unfortunately.
And if any of you out there are curious, how are you in deed on your house? Are you and your husband, or you and your wife? Are you, do you have a joint tenancy? Just put deed in the comments and I can check that for you later on today and get back to you with that information. So what if it is not a couple? What if it's mom and dad? Then what happens?
So in terms of, say, like with you, your mom and dad, if they own title, well, it's the same thing. If they have it as joint tenants with rights of survivorship, your dad passes away, it would go to your mom by operation of law. Now, when your mom passes, since it'd be in her individual name, in order for you to receive that property, it would go through probate.
Okay. And what about if there's a will? What if my mom has a will and it says, Kristen can take care of this if I pass away? Does that take care of everything?
Well, the will, there's a misconception in estate planning that a will keeps you out of probate. Although that a will is a letter of instruction to the courts of how you want your assets to be distributed. So if you have no plan and you pass away, the state of Oklahoma will actually implement their own plan for you. And
Oh
so if
no.
there's a surviving spouse and surviving children, then the spouse and the children will end up splitting the assets held in an individual name in varying shares. If there's a will, that's the way that if the husband wanted everything to go to his wife, a will at least allow that transfer of hit from him to the wife, and then the wife could have a will that goes to the kids in equal shares.
But
But
it
the
could
will
still
doesn't
go to
keep you
probate.
out of probate, yeah, because title has not been changed. Probate is based on how assets are held, titled.
So if someone has lost a loved one and they need to sell the house, and they find that it was in their loved one's individual name and it's going to have to go to probate, how long can they expect that process could take?
It's going to depend on a number of factors. Not to give the lawyer answer of it depends, but
Of course.
if the value of the estate is under 200,000, that's the value of all the assets, not just the house, but bank accounts, safety deposit box, personal property, all of that. If that is under 200,000, then you can go through what's called a summary or administrative probate process. And that process, by statute, can be no shorter than 45 days. It tends to be a little bit longer. And this is assuming that no one fights about anything. And so it can be a very big assumption depending on family dynamics. But theoretically, the whole thing could be done in 45 days. If
Uh,
it's
when,
over
yeah.
200,000, which is not uncommon if people just have a will-based plan, then it's easily going to be in the 6 to 16 month range. It could be a little bit less. It could be
Wow.
way more. Whitney Houston's estate, I mean, those kinds of estates could go 20 years before they're resolved because different people are going to be submitting wills saying, well, Whitney actually wanted to leave me more.
Everybody wants a piece of the pie.
Yeah, I mean, everyone ironically comes up with a will that names them as a primary beneficiary.
Kind of like winning the lottery and people just come out of the woodwork.
Exactly. Except there's some forged golden tickets in there.
Yeah.
But
Yeah, but in a typical, just, not your Whitney Houston's, but your, a typical household in Oklahoma, even those assets are going to be more than $200,000 easily.
I mean, yeah, you have an average home is what 150,000 in the Oklahoma City area,
Yeah,
and
about that.
retirement
So,
accounts, bank accounts, cars. I mean, it's not that hard to really get your estate over 200,000. And
so,
yeah, go ahead.
so then who gets to make the decisions like paying the power bill and all of those kind of things during that probate process? Does a judge determine who is, set somebody as being in charge during that time, or is that how a house could kind of fall in disrepair?
And that's a great question. And yes, I mean, at the end of the day, the judge is the one that makes that determination. So in your will, if you've got a will, you would name a personal representative or administrator or executor. There's executor, there's 100 terms for the same role. But essentially, that person is then tasked with the responsibility of winding down the person's affairs. And in order to become that, if someone is named in a will, doesn't mean they're automatically going to be that person. They'd file a probate petition and ask the judge for permission to serve as personal representative. In a summary probate, that process is pretty streamlined. In a larger probate, there's the petition, and then you have to set the petition for hearing to name the personal representative. And that can take 30 days or longer just to get that hearing set from when the petition was filed. And then anyone who has an interest in becoming personal representative can show up and say, you know what, John, even though John was named in the will, should not serve as personal representative for X, Y, Z reasons. So if there's family dynamic of drama or conflict, will can result in an additional conflict, even though a will has been created.
I
Now, the
think,
judge is going to likely go with the person named in the will, but it's not necessarily going to happen that way. And if there's no will, then it could be a free for all. And sorry, go ahead.
Oh, I was going to say, if there's no will, then, can it, it's like the oldest son gets kind of falls into that position, and can all of the family agree he's the one who they would want to be in charge, and so he's going to do it and ask the judge permission? Is that kind of how that would work?
Ideally, the family can come together on one person, whether it's the oldest child or the youngest child or the middle child, hopefully the most responsible child if it's a
Hopefully.
child. It doesn't have to be a child. It could be a brother, sister, aunt, uncle. It could be a complete stranger, but generally it's going to be family. And but yeah, I mean, ideally, there's no arguments about who that person is, because arguments result in multiple attorneys getting brought in, most likely, which means money that should be going to beneficiaries gets diverted to attorneys fighting over the pot of money that's there.
It seems that this could just be a long and emotional process, and you're going to give us a solution, right? How can we avoid this? What's the answer?
So I'm a big fan of trusts for a lot of reasons. One, a trust is a private document. So one of the things about a trust, and a trust is really just a box that you transfer your assets into, that so that when you die, you don't have any assets in your individual name. It's owned in your trust. And generally speaking, I'm going to talk mostly, especially about a revocable living trust. And in a trust, there's three roles in it. There's the trustor, it's the creator. The trustee gets to manage the assets. And then the beneficiary is the one that has the right to receive the assets in the trust. So generally speaking, when a husband and wife create a trust, assuming it's husband and wife or anybody, on a revocable trust, they're going to be all three of those roles. So they're the creator of it, they're the manager of the assets in it, and then they get to spend the assets in the trust for their benefit. It's going to have one of the person's social security numbers if there's more than one. So taxes are going to be unchanged. And then they're going to be able to refinance, buy, sell, whatever, if with any of the assets in there. But since we have transferred title into the trust, there's nothing to probate. Probate is a public process. It's the reason why, like with Aubrey McClendon, when he died, he had a will. Any assets held in his individual name would go to probate. And so you can go on OSCN and look up his probate records, which is kind of concerning to me that that's something that can be done. With a trust, everything that's in there is private. The only people who know what's in it are the trustee, beneficiaries. That's pretty much it. So I like that aspect to it. And if you have a trust, assets in the trust can be transferred to loved ones faster. Theoretically speaking, if the creator of the trust passes away and the trust already has someone currently serving as trustee, then that person can automatically transfer assets immediately, same day or next day, even after the person who created the trust has passed away. If no one was named at that time, then it's generally a 10 to 14 business day process in terms of getting a copy of the death certificate. So we can file a updated paperwork with the county to show that the different trustee is now in charge of the trust. And banking, financial institutions, title companies are going to want to see that documentation as well before they'll sign off or approve the assets being managed by the new trustee. But either way, it's a lot faster than 14 or 45 days to 6 to 16 months.
So this is something that that maybe people should talk to their parents about, and, asking them if they have their affairs in, if they've created a trust. Is it just something for, older people, or wealthy, or is it something that just anybody should consider doing?
That's one of the things that I have conversations with people fairly frequently is I don't have enough money for a trust. People think that you have to have a certain dollar value to have a trust, when in reality, a trust could be for anyone. If you're older than 18, if you're younger, depending on circumstances, a trust can be beneficial to anybody. And with an estate plan, I mean, a true holistic estate plan doesn't just involve a trust, but it also involves powers of attorney. And going back to that, just because you have the ring doesn't mean you have authority comment. Just because you have the ring on doesn't mean that you can take care of your spouse if your spouse becomes incapacitated. Such that whether it's a car accident or a coma or anything, you can't manage your spouse's 401k, can't file joint tax returns, can't manage financial assets or make healthcare decisions without a power of attorney. And in the absence of a power of attorney, going to court and being appointed the conservator or guardian of that spouse. Now, powers of attorney are preferable because you don't have to go to court to have that authority. Guardianship, conservatorship, you have to go to court and ask a judge for permission to become the guardian, the conservator, to manage your spouse's assets. And then every year you got to go back and provide an accounting to the court of, here's how I spend our money, do you approve? And that's generally a process that people don't like going through.
I would imagine.
I don't like going through it either, just because it is emotionally charged. And planning would have prevented that. And the process of guardianship tends to be more expensive than the pre-planning, the forward thinking of getting the powers of attorney in place.
A thought came to my mind when you were talking again about how the ring doesn't protect you, and that a lot of us, we kind of grow up thinking that as long as you're married, you have that kind of protection. But in fact, as we're learning, you don't always. But what about, can you have two individuals that maybe they're a couple, but they've chosen not to get married? Is by putting their assets into a trust, is that a way for them to protect and take care of each other?
Yeah, they can take care of it that way. It might be a little bit more interesting in terms of the tax implications of doing that. And that's where having a very well-respected tax professional involved in managing your tax preparation is good. But there's a lot of ways to handle it, and you don't necessarily have to be married to have a trust.
Okay.
Or
good.
They could each have their own trust that provides for the benefit of the other, the significant other, domestic partner, whatever the relationship, that for when one of them passes away, the assets in their trust goes to the other for their benefit. That's one of the nice things about estate planning in general, wills and trusts, both of them, is that you can really create anything that you want as long as it's not illegal, which there's a lot of leeway in terms of what's legal. So you can create something that's customized to what makes sense for you and your family.
And then it can be changed and edited over the years to work with and adapt to your changing needs?
Absolutely. So a will you can update with a codicil or create a brand new will. With a trust, if it's a revocable living trust or a living trust or revocable trust, whatever term you want to use, that can be amended, changed, or revoked at any time as long as the creator of the trust is still alive. Once that creator passes away, that trust becomes irrevocable and it cannot be changed.
Okay, got it. Now, I have heard, I'm going to back up a little bit. I've heard some people talk about a transfer on death deed. Mm-hmm. Can you tell us a little bit about that? And is that a good solution instead of doing a trust?
So the transfer on death deed is a derivation. It's come from the financial sector in a lot of respects, in that financial institutions, banks, investment companies have had transfer on death designations on accounts for a long time. And the premise behind that is that when the owner of the account dies, you provide a death certificate to that entity, and then they would transfer that ownership of the account to the person that's listed as the primary beneficiary on the transfer on death designation.
So that would be similar to a joint tenancy.
It's different. I mean, it's similar, but it's different in the sense that joint tenancy, it's two or more people that own it. Transfer on death is generally one person transferring to another after.
I understand. Okay.
Now, I'm not certain. I haven't dealt with the joint tenancy transfer on death deed. One of the issues that I have with transfer on death deeds is you can only name up one beneficiary, and if that person passes away, then the asset ends up going to probate.
Okay.
And so there's some potential issues on that side. Another thing is that there's potential tax ramifications to it. So in terms of taxes, when you die, the estate tax right now in 2018 per person, you can have up to $11.2 million in your estate. If you're married, that amounts to $22.4 million. It's a number that most of us would probably never reach. I mean,
Yeah,
I hope everyone that ever watches this reaches that number because I wish
that'd be
success for
great.
everybody.
And I'll sell you all the houses.
But the one thing that's tied to having assets pass through your estate is if you buy, say, stock, or if you have a rental property that you've purchased through you, Kristen, that you bought it at a certain price. So, say you buy a property and you bought it at $100,000, and that 20 years later, that same property is now worth 400,000. Well, if you were to sell that property at 400,000, as the owner of it, you have a $300,000 gain, not counting depreciation or any other adjustments to the tax basis, that initial cost. That there's a $300,000 gain subject to capital gains taxes, which generally amounts to about 20% between state and federal, that would be owed to the federal government and the state government for income on that sale. When you have joint tenancy, or if you give an asset away, the basis, that $100,000 value, goes with it, so that the loved one who takes the property through that transaction receives that property as if they bought it at $100,000. So that if they sold that same property for $400,000, they also have to pay capital gains taxes on that $300,000 gain. If you transfer that same property through your estate, through a will, through probate, or through a trust, through the trust administration process, you can lock in the fair market value, because there's a step up in basis from that $100,000 to the $400,000 fair market value. So rather than when the family sells the property, same transaction, same value, that $300,000 gain that's experienced is not counted as a gain, because the one who received it, the loved one who received that property, gets it at 400,000 as the basis, the taxable basis. To the little bunny ears. So when they sell it, there's no taxes owed. It's one of the few ways to legally escape having to pay taxes.
Well, that seems like a really good reason to consider a trust, just for that, for the for that to avoid the capital gains.
Exactly, avoiding on appreciated property, passing it through your estate with the current estate tax levels makes the most sense to me.
So if somebody either is interested in creating a trust to protect their own property, or they would like to, initiate maybe getting their parents, I think that seems to be where a lot of people that I know anyway, where their mind is protecting their aging parents' property to kind of protect and make their lives easier, on down the road. So if that was something that they wanted to pursue, what would be the first steps? How would they go about creating a trust?
Well, so the first step is getting together and deciding let me start. The first step would be getting together with an attorney that's experienced in estate planning. I generally encourage people to talk to an attorney whose practice centers around estate planning, not one that dabbles in real estate and oil and gas and litigation, and also does some estate planning, but focus on an attorney that makes their practice, whether it's me or someone else. Obviously, I would prefer they work with me, but rather more than anything else, I want people to be protected. I mean, statistics show that $2 billion a year are lost to the probate process. And probate can result in a lot of money going to attorneys that doesn't need to go to, and can result in money being tied up for months on end or years on end when loved ones need access to it before. And it's just, most people have no plan. And so having a plan in place can make it easier on your loved ones when you do pass away, because we still have no cure for death. And until we do, then we'll need to be thinking about what happens when we pass away. And most attorneys are going to offer free initial consultations to get together to let you know what your options are. I mean, I take a very educationally based approach. I like to tell people, here's what your options are. And then I do flat fee based billing. So I tell people, here's what the cost will be. And this is how long it'll take to get it together. And do you want to move forward, yes or no? I don't like to do high pressure timeshare sales kind of things, because it's really about making sure that people get a plan that matches what their family needs. And they know better what that is than I would. I just want to help facilitate that discussion, whether it's with me or another attorney that they work with. I just want them to have planning in place so that their loved ones don't inherit a legacy of chaos from your estate.
Well, I think that's a good place to end, because I would say that just in my experience in helping people that have found themselves in that position where, somebody has passed away unexpectedly and they are now the person who is in charge of dealing with this house, it can be very difficult and very expensive to maintain that property during the probate process, because there's utility bills and carrying costs, all of those type of things. So I would encourage the folks out there, I've got your contact information there on the screen, so I'd kind of urge people to give Aaron a call and see about setting up a trust for your own personal property or for your folks.
Thank you. Thank you, Kristen.
You're welcome. Is there anything else that you think that people need to know about trusts before we say goodbye?
Just one extra thing. I mean, the real big benefit is by putting a plan in place, your family members, your loved ones don't have to worry what you want. They know because you put it in writing. And I think there's a lot of value in telling your family how you want things to happen, rather than them saying, well, mom told me this, and the other one saying, well, dad told me that. And that's worth its weight in gold, in my opinion.
I think that's a really good point, because that's the last thing that you want to try to guess when faced in that situation. You want to be able to just have a clear map that tells you exactly what you need to do, and so that you can get through it.
Absolutely.
Well, thanks for joining me today, and everybody, please share and give Aaron a call.
Thank you. Thank you, Kristen.
Bye, Aaron.
Bye.